Imagine showing up to work, doing your job, putting in your hours, and then your boss looks you dead in the eye and tells you that you simply will not be receiving your paycheck. Not because the company is struggling, not because you did something wrong, but because of a clerical error in a software system that only he has the power to fix. And he has decided, flat out, that fixing it is no longer his problem. That is exactly what happened to one worker in Minnesota, and what he discovered next is something every single person with a job needs to hear. Welcome back. Today we are diving into a story that is going to make your blood boil, but more importantly, we are going to break down exactly what the law says, what this employer got catastrophically wrong, and what you can do if you ever find yourself in a situation like this. Because this is not just one person's problem. This kind of wage theft, and yes, we are going to call it exactly what it is, happens to workers all across the country, and most of them have no idea how much power they actually have. So let us set the scene. We are in Minnesota. A worker, let us call him the employee, has been doing his job, clocking in, clocking out, and expecting to be paid for his time. His employer recently switched over to a new electronic payroll system. Now, on paper, that sounds fine. Lots of businesses modernize their payroll processes. The problem with this particular system is that it is extremely sensitive to errors. If a clerical mistake is made, something as simple as a missed time punch or an incorrect clock-in entry, the system will not process that employee's paycheck at all. It just holds it. It flags it and waits for someone with administrative authorization to go in and correct it. And here is the critical detail. Only one person has that authorization: the boss, the owner, the person at the top. He is the only one who can go into the system and fix these errors so that paychecks can actually be processed and employees can actually get paid. Now, up to a certain point, maybe this was manageable. Mistakes happen with new systems. There is a learning curve. Employees make occasional errors with time punches. You would expect the person running the company to handle those corrections as part of normal business operations. That seems reasonable, right? But then the boss called everyone together and made an announcement that crossed a very serious legal line. He told his employees that from that point forward, he would no longer be fixing payroll mistakes. Any error in the system, missed punches, incorrect entries, anything that triggers a hold on a paycheck, would simply not be corrected. And if the paycheck cannot be processed because of an uncorrected error, then according to this boss, that employee simply would not get paid. Full stop. Let that sink in for a moment. This man is running a business. He is the sole person with the ability to authorize payroll corrections, and he has just announced to his workforce that he refuses to use that authorization. Meaning employees who make any kind of time entry mistake, even an honest minor mistake, could end up working an entire pay period and receiving absolutely nothing. The employee who submitted this situation online knew immediately that something was deeply wrong. He stated, and I am paraphrasing here, that he knew this could not possibly be legal and wanted to know what his options were. And he was absolutely right to question it, because what his boss announced is not just unethical. It is a clear violation of federal law and Minnesota state law. Let us talk about the law, because this is where things get really important. Under the Federal Fair Labor Standards Act, commonly known as the FLSA, employers are required to pay their employees for all hours worked. That is not a suggestion. That is not optional. It is a federal mandate. If an employee works, that employee must be compensated. Period. There is no provision in the FLSA that says an employer can withhold wages because of a software error or a missed time punch. None. Now here is something that trips a lot of employers up. The responsibility for maintaining accurate payroll records falls on the employer, not the employee. The law is very clear about this. Employers are required to keep accurate records of hours worked and wages paid. If there is a dispute about hours, if records are incomplete or inaccurate, courts and the Department of Labor will typically side with the employee when there is evidence they worked and were not paid. And Minnesota has its own wage payment laws on top of the federal protections, which makes this situation even more legally precarious for this employer. Minnesota Statute Chapter 181 governs wage payment in the state. Under Minnesota law, employers must pay employees their earned wages on regularly scheduled paydays. Failing to do so exposes the employer to significant legal liability, including potential penalties. Minnesota also allows employees to recover attorney's fees if they successfully pursue a wage claim, which is a huge deal because it means employees can fight back without necessarily having to front enormous legal costs. So what this boss essentially did was announce, in front of multiple witnesses, his intention to systematically violate both federal and state wage laws. And here's the almost absurd irony of the situation. The very mechanism he is using to justify withholding wages, the payroll software, is a system he controls entirely. He is the only one who can fix it. So his refusal to fix it is a deliberate choice. This is not a technical glitch beyond anyone's control. This is one person with all the administrative power choosing not to exercise it so that employees go unpaid. From a legal standpoint, this is about as clear-cut a wage theft situation as you will ever see. And the employee asking for help had several very powerful options available to him. The first and most immediate step is filing a wage complaint with the Minnesota Department of Labor and Industry. This is a free process. You do not need a lawyer to do it. You go to the department's website or contact them directly, and you file a complaint detailing the situation. The state then has the authority to investigate the employer, compel payment of wages owed, and impose penalties. This is often faster and less complicated than going to court, especially for workers who cannot afford lengthy litigation. The second option is filing a complaint with the Federal Department of Labor's Wage and Hour Division. This is the federal agency responsible for enforcing the FLSA. Again, this is a free process. You provide the details of your situation, the agency investigates, and they have substantial enforcement powers, including the ability to recover back wages and impose civil penalties on employers who violate wage laws. The third option is consulting with an employment attorney. Many employment lawyers take wage theft cases on a contingency basis, meaning you do not pay them unless you win. And because Minnesota's wage laws allow for attorney's fee recovery, these cases can be financially viable for attorneys to take on, even when the individual dollar amount at stake might not seem enormous. There's also one more thing this employee and his coworkers should be doing immediately, and it is something everyone in any job situation should make a habit of. Document everything. Keep personal records of your hours worked. Write down your start time and end time every single day. Keep copies of any communications from your employer about payroll policy, including that announcement the boss made. If he put anything in writing, an email, a text, a posted notice, preserve it. If the announcement was made verbally, write down as much as you can remember, including the date, who was present, and exactly what was said. This documentation becomes evidence, and evidence wins cases. What every working person needs to take away from this story is that your wages are not a gift from your employer. They are legally protected compensation for your labor. An employer cannot simply decide not to pay you because a system is inconvenient, because paperwork is messy, or because they do not feel like dealing with corrections. That is not a valid reason under the law. It is not even a gray area. Courts have been extremely consistent on this point. If your employer is doing something similar, withholding pay, shorting hours, manipulating time records, making deductions that were never agreed to, you have options. Real, legally backed options that do not require you to just accept the situation or stay quiet out of fear of losing your job. Retaliation against an employee for filing a wage complaint is itself illegal. That is another layer of protection the law gives you. The bottom line is this: the moment an employer tells you that you are not going to be paid for work you performed, that is the moment you need to take action. File a complaint, consult an attorney, document everything, and do not let anyone convince you that powerlessness is your only option, because the law was designed specifically to protect workers in exactly these moments. If this happened to you, if your employer has ever withheld your paycheck, manipulated your hours, or refused to correct the payroll error that left you without your earned wages, do not wait. Start by contacting your state's Department of Labor and the Federal Wage and Hour Division. You worked for that money. You earned it. and the law says you have every right to fight for it. If you found this video helpful, please subscribe so you do not miss our next one. We cover real legal situations that affect real people every single day, and we break them down so you know exactly where you stand. Your rights matter. Make sure you know them.